the invitation here, and thanks to Cameron and the organisers and the good crowd we've got here tonight, because this is, as Barry's pointed out, a great threat to our civil liberties. And I'll cover the surveillance side and search side shortly, but I think just beginning with the surveillance side, the context of surveillance now is quite different from it was that which existed a few years back. A number of us have got our SAS files recently, and the nature of surveillance was quite different in the earlier times. For instance, let's look at visual surveillance that Barry's mentioned. Previously, you had people sort of standing outside political offices, or sitting outside in cars, and that sort of time-consuming form of visual surveillance. Now, as Barry indicated, there's much more complex technology, video cameras everywhere along the streets and airports and shops and offices, and you name it, with facial recognition systems sort of built in, so they don't actually have to look at all the video footage, and we have sort of overhead surveillance, drones being used more, not only in war situations, but I heard somebody going to transfer them to London to try them over London, and satellite imagery. There's all kinds of surveillance these days that is quite different from the old surveillance. So the tracking systems, which is the surveillance warrants cover visual surveillance, tracking and interception. Now tracking, if you look at my SAS file, or my mother's SAS file, consisted of SAS agents sort of plodding along behind and all the rest of it. That was their tracking system. On my email a couple of weeks ago, I got this advert for, you can buy it for 200 and something US dollars, a little device that you can pin on somebody, and then you've got a little thing like a pen drive you put in your computer, and you can track them everywhere they go, and it's advertised to keep track of your kids, your partner, your friends, enemies, employees, whatever. And the state agencies, of course, using these too. It just shows you the advance in the technology that allows much more of that. Let's look at interception. Well, in the days of my SAS file a few years, covering activities a few years back, it was mainly the interception of communications, mainly opening letters and listening to phones, perhaps breaking into a house and looking at some stuff there. But again, it was rather time-consuming, limited by personnel, listening to the phone calls, or opening the letters and then fixing them back up again and all the rest of it. But now, with electronic technology, millions of communications can be intercepted at one time. The Waihopai system that New Zealand is unfortunately part of, the Echelon system, intercepts millions of phones, faxes and emails that pass through communications satellites over the Pacific equator, and uses keyword searches, so they can search present communications through that keyword system, or they can search accumulated communications, such as on your computer, through keyword searches as well. And then there's a final form of surveillance warrant that Barry mentioned. They're called residual warrants, and that covers any, quote, technique, procedure or activity that may constitute an intrusion into the reasonable expectation of privacy of any person. So that's anything at all relating to any person. So it's pretty broad ranging. Now the authors of the bill say, oh, we're putting all these reporting procedures and controls and warrants and all the rest of it. So actually you're going to be safer because it's all going to be more structured. And to some degree that's true. They said, well, previously there wasn't anything around visual surveillance. Now we've got warrants for visual surveillance. But they don't tell you that there's additional powers thrown in there too. That is, they can now trespass a property to install visual surveillance devices. So let's go on to the search warrants, and as Barry's indicated, it's not just the police, it's about 70 different groups under 70 different acts, and they can do a lot of work under the bill. There's a whole lot of sections on warrantless search that they can, without any warrant, they can go and search either a house or a car or a person for 72 hours if that person was supposedly engaged in criminal behaviour with 14 years or more imprisonment. Then there are the production orders that Barry has talked about. Previously, when the Serious Fraud Office was set up, it was all said, oh, this is, the powers that the Serious Fraud Office were given, which, were powers to get documents are only for this complex business, white-collar fraud. You don't need to worry, folks, because it's just that it's so technical, you have to have this power to sort of get at it. But now these production orders can apply to anyone. Not only people seen to be guilty of some crime, but anyone. Some can, and not only a police officer, but another officer of one of these other agencies can come and say, well, look, I think you might have some information relevant to a crime. I'm not accusing you of anything. Just hand over this document or that document. And it may incriminate you, you don't know. And they say, oh, there's a protection there because you can use another provision of an act against self-incrimination. But how do you know what's incriminating you or somebody else? You don't. You just are ordered to give over this document. If you don't, you can get a year in jail. Interestingly enough, some of the telecommunications agencies like Telecom are a bit worried about these production orders because it's going to mean they're going to have to store a lot of information on communications and exactly what people are saying over the telephone and everything else, and it's going to put them into huge millions and millions of expense, and so they're getting a bit upset about it from their own sort of profitability angle. Then the examination orders, that Barry's talked about, where you're forced to answer questions. This can apply to political activists, like many of the people in this room. Often, a Greenpeace group goes out to do a bit of non-violent civil disobedience. Technically it's against the law. Sometimes, technically the offence can carry along a sentence. But under this examination order, if there's 3 or more people working together, as in most proposed actions, it's 3 or more usually involved, and it infringes the law, you can be required to answer questions about what you're doing, what your mates are doing, and if you don't, it's a year in jail. So that's pretty heavy stuff and undermining a traditional right not to have to answer questions, the right to silence. The question of computers is one I've indicated before is a very intrusive one. Like, I don't know about you, but most of my life's on my computer, and so an agency, the police are an agency, grabbing your computer, searching your computer is a huge intrusion into your privacy. And you are forced under, some of the laws are imported from previous laws, that's true, like under the laws passed 2003, 2004, the police were given a lot of rights in relation to computers to access them remotely and to hide their tracks, to hide the fact that they've ever been there, that is to hack into your computer, and also there was a requirement for you to assist with passwords and things like that so that they could get into your computer, and those powers are sort of transformed into this legislation, although they are extended a bit in that now you have to assist to let the police into your computer or some other computer in the building you're in, even in a warrantless search, or a search that hasn't got a warrant, and there's a whole section on warrantless search there.